Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We are on the record in CR 20-0161. This is State of Arizona versus Troy Thomas York. This is the date and time set for oral argument. A couple of housekeeping matters. We are socially distanced here on the bench, and we'll have our masks off so that you can hear us when we speak. If you're comfortable, you're welcome to take your mask off during your argument. You're also welcome to stay seated. That way we're not cross-contaminating at the rostrum there. Each of you have 20 minutes for your argument, and Ms. DeWalsh? Am I saying that? DeWalsh, thank you. If you would like to reserve any of your time for rebuttal, that's up to you. You'll just need to keep track of your time. If you need to look up on the rostrum there's a clock there. Hopefully you can see that from where you're seated. We've conferenced the case this morning. We've read the briefs. We're familiar with the record, so just keep that in mind during your argument. And with that, Ms. DeWalsh, go ahead.
Thank you, Your Honor. Good morning. May it please the Court. My name is Michelle DeWalsh of the Maricopa County Office of the Legal Advocate, and I represent the appellant, Troy York, in this matter. The right to a trial by jury is a cornerstone of our justice system, but in order to be able to perform its civic duty, a jury must be properly instructed on the law. A jury must be presented evidence that is untainted by prosecutorial error or misconduct, and a jury, not a judge, must find any allegation of dangerousness which would enhance a defendant's sentence. None of that occurred in this case, and for that reason, Mr. York was deprived his right to due process and essentially his right to a jury trial. We would ask that this court reverse and remand the case to the trial court for a new trial, or in the alternative, to remand the case for resentencing in the non-dangerous, non-repetitive offender category range. And so none of the error that is in my brief or that is being raised in this appeal was objected to. And for that reason, Mr. York has the obligation of showing that A, error exists, B, the error is fundamental, and C, that he was prejudiced by that error if it is not that third prong of Escalante, which made a fair trial impossible. And so here, with the deficient jury instructions, I would like to begin with those. The self-defense jury instruction, I don't think that there's any question that that is a deficient instruction, in that it does not include the language that shifts the burden of proof from the defendant to the prosecutor. And so that instruction itself is missing that language. And so we do have error here. The reason that this error in this case is fundamental, whereas in say, State v. Cannon, it was not, is because not only is that language missing in this case, but we have that coupled with that instruction being immediately followed by a crime prevention instruction that includes the burden shifting language, but also specifies that shifting of the burden of proof applies to this instruction. Now, the judge...
Ms. Walsh, if it had said to these instructions, would we be having this argument?
Your Honor, no, I don't believe so. And that was my next point. I believe if the judge wanted to save the time, and I know that often occurs, this could have been remedied simply by changing those words to these instructions. But we presume that jurors follow their instructions, and if they did so here, that would leave them believing that the self-defense instruction does not shift the burden of proof to the state, whereas the crime prevention instruction did. And so it's the combination of those two that causes this to be misleading for a jury. And we know from State v. Hunter that if a jury could interpret an instruction incorrectly, and they go through 3 different examples of how it could be interpreted differently in Hunter, that could have happened here. And so we know that the jury could have reached a different verdict absent the error in these instructions.
Mr. Walsh, let's say, for argument's sake, I agree with you that the judge actually made it worse by having the burden shifting following crime prevention than if he had put no burden shifting in there at all. Arguably, that takes it clearly out of Hunter and Cannon. But doesn't it also demonstrate beyond any doubt that your client wasn't prejudiced? Because the jury rejected the burden shifted argument on crime prevention. I don't see how a reasonable jury, or any jury for that matter, could find that the state had met its burden on crime prevention, but not met its burden on self-defense.
Your Honor, I believe that for two reasons. First of all, we don't know why the jury rejected the crime prevention defense. One of the reasons could have been, and there was evidence at trial, the prosecutor did state even in closing argument that based on the testimony of the medical examiner, you shouldn't believe Troy's story that the chair was being wielded at the time that the shots were fired because of the blood spatter on the chair and the way that they were arranged. And so if the jury truly believed that version of events and did not believe that he was wielding a dangerous instrument at the time of the first or second shot, the jury could have found or rejected that crime prevention defense, but then also have accepted the self-defense offense, because there was also testimony that Greg York actually lunged at him after the first shot. He was lunging at him.
But if he was lunging without a dangerous instrument, how could he be in reasonable apprehension of imminent death, basically?
Well, and I do cite the case in my reply brief. I believe it's, and I don't know the pronunciation, but we have State v. Almaguer, Almaguer, where a self-defense instruction was appropriate absent any use of a deadly weapon or dangerous instrument, and that was involving a fist fight between two individuals. And so because of the lunging and the saying, I'm going to rip your throat out or your face off or whatever it was, the jury could have found self-defense without the dangerous instrument. And it's important to note in the crime prevention instruction, the jury was instructed that it is aggravated assault with a dangerous instrument. They were not given any other alternate theory. And so if they did not believe that a dangerous instrument was being wielded at the time of one or both, or the first or second shot, I believe it is possible for a jury to reject crime prevention in this case with these facts and still accept and find that the state had not met its burden of proof on self-defense.
Let's go back to the instruction portion of this. Let's go back to, let's say it is error that the burden shifting wasn't involved in the self-defense justification defense. We go down to and include counsel's arguments. The defense attorney spent a lot of time explaining this burden shifting in regard to both justification defenses. So does that not cure any potential error?
Well, I think when you look at the transcript where the defense counsel was, reading really the instruction to the jury and trying to clarify that, when he was making that clarification that, oh, wait, this actually applies to both of these defenses, he was cut off in the middle of that by the court reporter who couldn't hear what he had said. And when he returned to it, he simply repeated the language in the crime prevention instruction that it applies to this defense. And so I don't see that in any meaningful way provided clarity for the jury in this case. And then also with the prosecutor, the mention of the burden of proof, or the state always has a burden of proof, was really in respect to the fact that the defendant did not bring in that missing piece of the chair. And so it had nothing to do with the burden of proof shifting to the state for self-defense or for the crime prevention defense. So I think in this case, the attorney's comments don't clarify, and we can't know for certain that they did clarify, and we don't know why the jury rejected the defenses. And so I believe in this case, the error is certainly fundamental in that it misled the jury, and then prejudicial because we don't know why the defenses were rejected.
But haven't you just acknowledged that you haven't met your burden? Because you bear the burden of proving prejudice under fundamental error review. And there's case after case that says saying we don't know or speculating isn't sufficient to meet that burden. So how can we reverse? What is the proof we can look at in the record that shows that the jury would have come to a different result?
Well, first I would point out that the burden is just showing that the jury could have reached a different verdict.
What's your authority for that?
That's State v. Escalante.
That
and-
it could have? State v. Escalante says, to meet your burden, all you have to do is show that it could have.
Yes,
Okay.
that the jury could have reached a different verdict. And I know there is some confusion. There's State v. Henderson where it was a would have standard that was used. However, that was a very specific to that case where, based on the decision in Blakely v. Washington, which came out while the case was still pending, they kind of went back to it and said, okay, would the jury have found beyond a reasonable doubt all of these aggravators? And so in State v. Escalante, they do set forth that could have standard. And so in this case, the jury certainly could have reached a different verdict. And I would also point out that it's not necessary to have affirmative evidence that the jury was confused by it. It's the fact that we have to speculate, as to whether or not the jury made the right decision and applied the appropriate burden of proof that is the problem here. And certainly the jury could have reached a different verdict if properly instructed. And we presume that they did follow the instructions. If they did so, then it is likely that they did not apply the proper burden of proof to the self-defense instruction. And regarding the dangerous instrument instruction, the dangerous instrument, as it was defined for the aggravated assault, the underlying aggravated assault, was just described as an object that could cause death or serious physical injury. And in this case, where we don't have a baseball bat, we don't have a gun, we don't have a golf club or something like that, which may often be used as a weapon. What we have is a regular household chair. It's a dining chair. And so in this case, specifically, to leave out those important words of in the manner in which it was used or attempted to be used was simply too vague for the jury to be able to make an adequate determination of the crime prevention defense. And
Mr. Walsh, the instruction, the way it was given, wasn't it actually more beneficial to Mr. York?
Your Honor, I respectfully disagree, and specifically in this case. I think in other cases, again, where the object that was used is more similar to what people, laypersons may consider a weapon. Because this was a chair, I think in the manner in which it was used adds that specificity that is required. Otherwise, the instruction as it was given was pretty vague, and the jury, we don't know if they rejected the defense because they came to the conclusion that a chair is not a dangerous instrument. And so,
Mr. Walshy, did the state ever challenge the fact that a chair used in this manner could be a dangerous instrument?
Yes, Your Honor, and that's the next thing I wanted to speak about is that the prosecutor in this case at one point sort of conflated the standard for that someone has to be in fear for their life, which would be in the self-defense instruction, and the standard for crime prevention. And in doing so, she says, well, this is obviously not a dangerous instrument. It's not like he broke off a piece of the chair and tried to stab him with it. And so I think given the fact that the instruction was overly broad and was overly vague, coupled with the fact that the prosecutor really insinuated to the jury that, he has to have done something to it to make it capable of stabbing Greg in this case, I think that would likely misled the jury. And so for that reason, we would ask that the case be...
If we go to the testimony of one of the detectives who basically testified specifically that the chair and a gun are equally lethal, that they're both dangerous instruments that can cause death, does that not clarify for the jury that it really isn't an issue?
Well, I think that the statements by the detective, made in passing, I don't believe that provided the necessary clarification, and I don't think it gets beyond the fact that the jury needs to be properly instructed, and in this case, they certainly were not, and we can't know what the jury was thinking. And so I don't believe that that one statement by a detective, coupled with the prosecutor's statements, provide the clarity that the jury needed in order to find that a chair is a dangerous instrument. Regarding the prosecutorial misconduct in this case, the prosecutorial misconduct it was pervasive, it was persistent. And I say that, I know that this is not the Arias case where we had all of these examples of prosecutorial misconduct from, a 30-day trial or whatever it was. However, in this case, we also don't have that overwhelming evidence of guilt, the other overwhelming evidence of guilt that was present in the Arias case. And so while this may seem more minor than that and not as persistent and pervasive, the nature of the misconduct or the error in this case really went to the credibility of Troy York. And the argumentative questioning...
Mr. Walshy, wasn't Mr. York also argumentative in refusing to answer even factual questions directly?
Well, if you look at the transcript, it seemed that he had a lot of confusion about the questions, and he seemed ill-equipped to answer the questions in which the prosecutor was attempting to get him to agree to something that he did not agree to regarding photos or whatnot. As he said, regarding the positioning of the chairs, he says the way that they're positioned, I can't tell if one is on top of the other. I think it was the nature of the questioning and the pressing those questions over and over again that constitutes misconduct. And a lot of it was, those photos were already in evidence. This prosecutor did not need Troy to agree, to her theory of the case in order to be able to argue that in closing. And so essentially what was happening is that she was undermining Troy's credibility and trying to show the jury that he was not answering her questions. In some cases, for example, the 911 call, the fact that he hadn't heard it before trial, he did not time it. And it really made no difference to the case whether or not Troy York said on the stand, yes, it's 5 minutes long or between 5 and 6 minutes long, and yet she continued to press him. And you know that these questions were argumentative, exceedingly so, because the judge felt a need to admonish this prosecutor several times during the cross-examination. And yet she continued to ask these types of questions, one of which were really just comments on the evidence, saying, did the bleach bottle, grow legs and walk over there? That is obviously not intended to elicit any admissible evidence, but is instead, directed to try to show the jury that Troy York is lying. And so for that reason, that coupled with the fact that this prosecutor misstated the evidence and implied that defense counsel was lying and said, you know what, don't believe, or I just want to remind you that what defense counsel argues is not evidence. Well, defense counsel factually summarized the evidence in this case, and that was that Greg lunged at Troy prior to a shot being fired. And so by misstating that evidence and then implying that defense counsel was lying to the jurors, defense counsel himself, this wasn't about his theories of the case, that added to any prejudice that he would suffer. And then finally, the using the compulsory process clause to imply that Troy York was lying was, just a violation it was misconduct because it is assuming that he has benefited from watching the trial, and the only conceivable reason for having asked that series of questions was to show to the jury that he had plenty of time and plenty of information to manufacture this defense. Regarding the dangerous, and I don't have much time, however, the dangerousness was found by the judge in this case. And the judge found that because of the finding of serious physical injury, that it didn't have to go to the jury. However, that ignores the fact that the jury did not find second-degree murder and instead found either reckless manslaughter or manslaughter by sudden quarrel or heat of passion, either of which would not necessarily involve an element of intentional or knowing infliction of serious physical injury. And so because of that error by the judge, this wasn't sent to the jury. And so for that reason, Mr. York, I we would ask that this court remand this for resentencing in the non-repetitive, non-dangerous offender range. It clearly was a mistake for the judge to not have sent it to the jury, and in this case, I think that Mr. York's prejudice is obvious in that he's serving a 7-year sentence. And with that, I would like to reserve, if there are no questions, my remaining time.
Looks like you've got just shy of a minute and a half left. So, all right, Mr. Knobloch.
May it please the court, Eric Knobloch for the Arizona Attorney General's Office representing the state of Arizona. On all 4 issues that York presents to this court, he fails to satisfy his burden of proving fundamental prejudicial error. If we look at the first issue, York asks this court to rely on Hunter, but that reliance is misplaced because in that case, the actual instruction itself was deficient and created the risk that the jury would feel that it was the defendant's burden to prove justification. Here, the question is more of, okay, does it apply to the one justification or does it apply to both justifications? So that is an important distinction here.
I'm only one member of this panel, but I will tell you now that I think that you're actually worse off by the fact that the court instructed as to the second justification defense than it would be if there had been no instruction. Because that seems to leave the implication by saying this justification defense that maybe it doesn't apply to the previous one. So how do you respond to that?
Well, I think, and Duarte talks about that. They talk about not the different instructions, but that the court can look at the entire context of the remaining instructions as well as the parties closing to determine whether or not that was confusing to the jury. And in this case, there was no confusion.
I don't read anything in the prosecution's closing argument, and I can't say that I've read every second of it. But looking at the excerpts that seem to apply to this, I don't see the prosecution ever actually clarifying, as you see in Duarte, where they say, hey, we bear the burden. It is shifted to us on this self-defense justification.
Well, and I think what's important is that the state accepted the burden.
Am I missing anything? Do you see that anywhere?
Well, as opposing counsel, I think, pointed out, the state says that it always has the burden. And the state continually talked about its burden of proving the case. But
never specifically to the justification.
Never specifically
and
on
never
the self-defense.
That there's been a shifting back.
Never specifically on the self-defense, but it willingly accepted the burden. It never once suggested that the defense at any point has the burden of proving anything. And so I think that in addition to the defense correcting itself to say that these justification defenses was, as well as the context of the instructions, where if we look at the instructions, the justification defenses was grouped as one unit and wasn't broken up with any headings or anything that differentiated the different justifications. It was grouped as one unit, and it had the self-defense justification, then the crime prevention justification, and then the burden. And so that, including the instructions repeatedly referencing the state's overall burden of proving this case, essentially overcomes any speculation that York supports on or puts forward on.
Would you agree with me that this would not be the best way to handle this in jury instructions moving forward?
Yes.
How would you suggest the court could have handled this differently?
I think there were 2 separate ways that the court could have handled it. The court could have handled it by putting the burden at the end of both justifications, so the self-defense and then also the crime prevention, or the court could have put it at the end, but referencing these defenses, these justification defenses. That way, we wouldn't have to go to the context of the rest of the instructions, or the parties wouldn't have to correct this during closing to make it clear.
Thank you.
But ultimately, this is not a case where it can be construed as anything other than a case where the state had the burden, and thus it is not reversible given that it's York's burden on appeal of showing fundamental prejudicial error.
So if you concede that this instruction was error, Can we get to why there is no prejudice to the defendant?
Yes, and I think, again, that's when we look at the whole context to show that even if there was error in saying this defense versus these defenses, or putting it at the end of each justification defense as we discussed, that's where the rest of the instructions, the closing arguments of the parties, that's where it really resolved any confusion.
Can you speak to Mr. Walsh's assertion that the jury could have not bought the justification defense, but self-defense could still have been found had the instructions been clear? Do you believe that to be the case?
No, and I think the evidence overwhelmingly shows that it supports their verdict of, and I talk about this as well in the prosecutorial error argument, that the overwhelming evidence shows that the jury's verdicts were supported by that evidence. And in that sense, they found him not guilty of, or acquitted him of second-degree murder, but they didn't find that it was enough to acquit him of manslaughter, because the evidence showed that there was testimony about the blood splatter and how that showed that he was standing at the doorway and that he wasn't holding a chair over his head. There was specific testimony that said that situation, that scenario, that theory was unlikely. And also the fact that when he was arrested, when York was arrested, he had a pocket knife on him and pepper spray on him, which were far less lethal alternatives to a gun. And also there was testimony about the marks that were on him. I think York had testified that he had been struck over the head, but the officers found no marks on his head or no injuries, visible injuries. And the only visible injuries that they observed were red marks on his back, from which the officer noted had arose after he had been sitting in the vehicle with handcuffed behind his back. And then when he reassessed him, or I think it was another officer reassessed him before interviewing him, he noticed that those marks were gone, but new marks had arisen that were consistent with the chair he had been sitting on. So there really is no evidence to back up defendant's theory that this was self-defense and that he only had the reasonable means were to use that gun to stop him.
Can you address the testimony where he says the brother was lunging at him?
And I think that almost goes against what he was saying, because he was arguing that he was using the dangerous instrument of the chair. But if he was lunging at him, then he was, in that case, not using the chair. And so that kind of goes against the crime prevention. Self-defense, I don't know if it backs up the theory that he could use deadly force if he was lunging with him with no means of actually killing him when he has pepper spray on him as well as a pocket knife. So less deadly means to prevent him from attacking him. And then shifting on briefly to the prosecutorial error claim. The state would first note that the Supreme Court has recently reframed these issues as prosecutorial error and not misconduct, because misconduct evinces a type of unethical conduct versus whether or not the defendant received a fair trial. And that was in Ray Martinez. But also, looking at the cross-examination of the defendant, a lot of the alleged error in this case arose because the prosecutor was attempting to clarify the answers and factual inconsistencies that the defendant gave during his cross-examination. And a lot of the defendant's answers were evasive and non-responsive, and so the prosecutor was trying to, for the jury, get those answers, correct any factual inaccuracies, but also make the answers clear for the jury. And specifically, I would like to address a couple points that opposing counsel made. First of all, the trial court's admonishment, I would note that the trial court does have an inherent authority to control its courtroom, as well as keep the record clear. And so when you'll often see when parties are talking over each other that the trial court says, please, one person at a time, but it in no way says anything about whether the prosecutors was doing anything inappropriate. And also, the state would like to respond to the undermining the credibility of the defendant. When the defendant gets up on the stand, he puts his credibility at issue. The courts have said that time and time again. And so that's what the prosecutor was trying to flesh out, that the theory that the defendant had laid out didn't meet the evidence. And that goes back to what I discussed earlier that I wanted to bring up, the non-prejudicial based on the overwhelming evidence. And that is that the evidence dispelled the defendant's theory. And the prosecutor made that clear. The fact that the defendant had less deadly means to prevent York from attacking him. The fact that the evidence or the crime scene, which the officers noted was very dusty and I don't want to say cluttered, or I would say cluttered, and it didn't match up to what York was stating on the stand, that there was a struggle that occurred in his bedroom because the officer stated that there were cans neatly stacked and orderly that were in a precarious position that hadn't been knocked over. And the blood splatter looked more like on the chair that it was a progression after he had been shot, was walking towards the door where he ultimately was found. That was more as an after movement versus him attacking Troy. And so there was extensive testimony that stated that evidence just did not match up with defendant's theory. And also I would note that on a number of these, or actually all of the egregious conduct that York points out on appeal, defense counsel didn't find it objectable.
So are you agreeing that the prosecutor's conduct was egregious?
No, I'm saying allegedly, sorry,
Okay.
Allegedly egregious. That the defendant at that point didn't find it objectable, didn't want to object. And so I do think that is notable. But the bottom line here is that even if the prosecutor did err at some points, that it is not the case where those errors were so pronounced and so persistent that it permeated the entire atmosphere of York's trial.
Counsel, let me ask a question about sentencing. Would you agree that it should have been the jury that found the offense to be dangerous?
I think, so in this sense, I think the dangerousness should have been put to the jury in that part, but it was not prejudicial because no jury could have found that this wasn't a dangerous offense because he had used a gun to shoot his brother twice with bullets that had been modified more like buckshots. And at trial, York basically conceded the fact that he shot his brother. So I think it's not prejudicial because there is no way that a rational jury could find.
Is defense counsel correct, or your opponent correct, that the court didn't rely on that, though, relied on the injury as opposed to the weapon?
Well, I think when we're looking at non-prejudicial, we can look at both to find whether or not that any error ultimately prejudiced him. And I think here the court or a rational jury would have found that the dangerous weapon was the gun. If there are no further questions, the state respectfully requests that this court affirms York's conviction and sentence.
Thank you.
Thank you, Your Honor. Obviously, briefly, since I haven't much time, I just wanted to address a few things. First, regarding, whether or not any reasonable jury could have found that this was not a dangerous offense, we do have cases, and Arizona allows for these inconsistencies in verdicts in cases like State v. Parsons, I believe also in State v. James, where a jury does find that, convict of an offense like aggravated assault that requires the use of a deadly weapon, and also finds that the offense was not dangerous. And so those presumably reasonable juries did find that inconsistent verdict, and that could have happened in this case. And that's why Mr. York has shown prejudice to that effect. And regarding, whether there was enough evidence for the jury to have found, whether or not there was, self-defense or what, that is not the standard for showing prejudice. The standard is, could the jury have reached a different verdict? Not would the jury have reached the same verdict. And so when you look at that and you think, well, a jury, if properly instructed, could have found self-defense, then prejudice is shown. And that is not speculation. That is borne out, I think, by the case law and the facts of this case. And then finally, briefly, counsel mentions that because the defense didn't object, that somehow undermines prejudice. That is citing other circuits' cases. We have case law on point at State v. Escalante, where the Supreme Court in that case did say that a mere failure to object is not evidence, that shows that there was no prejudice. And in fact, that court actually.
Your time's up. Just a few more seconds to wrap it up.
That's
okay.
Thank you. And for these reasons, we would ask that you reverse and remand this case for a new trial, or to remand the case for resentencing in the non-dangerous, non-repetitive offender range.
Okay.
Thank you.
Thank you.
We thank counsel, both of you, for your argument. You've given us much to think about. We'll take these matters under advisement and issue a ruling in due course. Please be safe, and we are adjourned.